Testing 1 2 3. Testing 1 2 3. This is a test of the 7th Circuit Court of Appeals. Testing 1 2 3.
Good morning, everyone. We have 5 cases up for oral argument this morning. Our first case is Ferguson versus Aon Risk Services, appeal number 24-2017. Good morning, Mr. Luskin.
Good morning, Your Honors. May it please the Court, Scott Luskin for Appellants Ferguson. Aon committed more than once to provide notice of Clarendon's claim to SCB Radon and their insurers. Yet Aon, at least twice, did not follow through on its commitments, failing to use its judgment and expertise to properly communicate with the carriers. Aon merely provided notice to Gulf, the primary carrier, while failing to timely notify excess carriers Ferguson and Reliance. These all but admitted failures sound in both contract and tort. Yet the district court committed a reversible error in allowing Aon to avoid liability to plaintiffs who lost millions because of Aon's action, or I guess inaction. Aon should not be able to shirk responsibility. Plaintiffs are both third-party beneficiaries of the notice agreement and can sue Aon in tort directly for the broker's professional negligence. I respectfully request that the court reverse both orders below so the plaintiffs can try their case to a jury. The court made several reversible errors in both the contract and the tort claims. For the contract, there were 2 key errors. First, the trial court applied the wrong standard to the third-party beneficiary analysis and then weighed the evidence, which Aon does again in its brief by talking about how the evidence can be better understood. Or
Mr. Luskin, before we even get to that, I'm having a hard time seeing, especially for the 1999, what you claim are contracts, how the letters from Ferguson to SCB and that were then faxed to Aon, how those constitute a contract.
Sure, Your Honor. As this court held in Hernandez, an implied agreement can be any series of documents that sort of lay out some requirements and concepts here. And in that case, merely looking at websites and student handbooks and other things of that nature constituted a contract. Here,
but you have to have an offer. What's the offer?
Well, in this particular case, it's more of a request to discharge a duty, which is exactly what 302 comment D discusses, right? So we have a.
But again, what's the offer? What kind of benefit are they offering?
What kind of
and accepting?
Well, the Radon SCB is asking for assistance, and Aon is looking to maintain the business of SCB and Radon, right? That is the offer and acceptance. And in fact, there's not really even a consideration requirement under 302. One of the examples is, C asserts that A owes him $100. A does not owe this money or even think he owes this money, but rather than engage in litigation and in order to obtain peace of mind, A secures a promise from B to pay C $100. C is an intended beneficiary. There's no discussion about offer or acceptance here. It's just the request and then the acceptance to discharge a duty constitutes the contract. And we have the exact same thing here, Your Honors, in the letters, right? We have, Aon doesn't even dispute that we have the first agreement, which is Clarendon requesting that SCB and Radon provide notice. And then we have the obvious admissions by Aon where they said, yes, we got this letter, we read Ferguson's letters, we read the instructions, and we understood it was our duty and our agreement to provide notice to the carriers. We just screwed up. We only provided it to one, not the others. And I think that is really the key here.
I'm not sure they agree to that, but
well,
go ahead.
I don't know if they agree, but they did admit it. They're Mr. Hannington, who's the one that actually sent the documents just to Gulf, I believe he testified that he committed to giving notice to the carriers, plural. And everybody understood that the concept was to give carriers up and down the line. They even said that back in 2009.
Well, but even assuming that collection of communications, letters, documents, understandings from 1999 constituted a contract, the cases you've provided us about intent to benefit are where the parties have expressly stated an intent to benefit a third party. And here, it seems, with that collection of documents, Aon, assuming it's a contract, was intending to benefit Radon with what you say. It's this promise to communicate. It's this duty to communicate. Does that distinction with the cases even you've cited matter for us?
I think that the big issue, and this is what the trial court focused on as well, The big issue here is that the Supreme Court of Illinois says the promisee must intend to benefit. And here we have the promisee intending to benefit. Not only do we have the Sheehan Declaration where he says, yes, we intended to benefit our largest client, make them happy, and make sure there was insurance coverage, but the letters, the communications to Aon themselves point to the fact that Clarendon is specifically asking for this information to be provided, and then again, Aon agrees that it read the letters before, the Ferguson letters, before sending anything to Gulf. Again, it just screwed up. So in the case law we have, it is this concept of, does the promisee intend to benefit? And here, clearly, Clarendon and Radon, there's at least an issue of fact that they intended to benefit at Clarendon and then ultimately my clients. And I think even on this record, Aon, as one of the world's largest and most sophisticated brokers, would understand that the purpose of providing notice is to preserve policy rights. And in this particular case, this is a policy that was procured by Aon that paid directly to the claimant, right? It wasn't an indemnity
But
policy.
preserving rights is separate than the question of a contract or an express intent to benefit a third-party beneficiary. While they may understand those concepts, they are not directly linked.
Well, I think they provide a fact issue, and again, all we need here for summary judgment is a fact issue. First,
What is your strongest argument that the 1999 letters that were exchanged or communications that were exchanged, that there is an express intent in there to benefit Clarendon? What's your strongest argument?
our strongest argument. So,
What language in there?
so the
makes it
language
clear?
in there, so the letters, the Ferguson letters specifically state, we're going to look to Radon and its insurers to provide to cover this loss, and we expect you to provide notice, right? So that piece comes there. Then in the faxes themselves, one of the faxes specifically says at Clarendon's request, we're asking you to do this. And then the other ones are this concept of, even there's a standstill agreement discussion, right? That could only possibly benefit Clarendon as the plaintiff, right? So there's all these pieces of information that provide us at the very least a fact issue as on summary judgment to get into whether A, there's a contract, and B, that there's an intent, again, from the promisee, here SCV Radon, to benefit
What's
Clarendon.
the strongest evidence that Aon had an intent to benefit Clarendon?
Well, I don't know, first of all, I guess, I don't know that Aon even needed intent to benefit Aon. Aon intended to benefit Clarendon because, again, the Supreme Court in Illinois says at least the promisee. Doesn't need to be both parties. But regardless of that, Aon read the letters, says they read the letters and committed to do what was there. And it doesn't have to be just for Clarendon's benefit. It has to be, it can be a partial benefit. It can be both benefiting its client and Clarendon. And I think we have here, again, based on the documents together, at least a fact issue to show that Aon also, in addition to the promisee who clearly, right, we've got the Sheehan Declaration and the faxes, clearly wanted to benefit Clarendon. I think there's at least a fact issue on whether or not Aon also was understanding and could intend to want to have Clarendon be preserved. Otherwise, they wouldn't be doing their job, and they would fail to be a worthwhile broker to SCB Radon, may not get the business again.
If we disagree with you on the express intent issue, if we don't think there's any evidence to create a fact on that, are you also arguing that you can rely on the duty owed test alone to establish third-party beneficiary status?
Yes, I think the duty owed test is separate than the intent to benefit test. Right, Illinois follows the restatement, and the duty owed test appears to be a separate way to show that you're intending to benefit someone.
All of the case law that you cited for the duty owed test assumed that there was already a third-party beneficiary and used it to determine if the third-party beneficiary's rights had vested, not to determine third-party beneficiary status in the first instance. How do you respond to that?
Well, Your Honor, obviously this doesn't come up all that often, but I respond to it by saying the Restatement 302 is the law in Illinois, and Restatement 302D gives many examples where you can have the discharging of duties apply without any further discussion, right? There's 4 examples we cited in our papers. Even one, which was number 9, A owes C $100, not knowing of any such debt, B promises to pay A $100 to C. And then we've got an intended beneficiary. That's all that's required under the restatement. And yes, the case law doesn't quite discuss that, but it does parrot and follow. And in fact, in Carson Peary Scott, the Illinois Supreme Court there, again, was discussing the restatement as the law of the land in Illinois for contracts.
I know you're into your rebuttal time, and perhaps the presiding judge will take that into account, but I need to ask you about professional negligence before you return.
Sure.
There's a case neither party cites, Santa Rosa. I don't know if you're familiar with it.
I am not, Your Honor.
Santa Rosa Mall LLC versus Aon Risk Services. It's 223 Illinois Appellate 1st, 221352. There, the Illinois Appellate Court ruled that the plaintiff was a shopping mall, couldn't bring a professional negligence claim against Aon for Aon's failure to properly manage insurance for the plaintiff's commercial tenant. Okay? And so the court is saying the mall can't sue Aon for the mall's losses because, quote, nothing in Illinois law suggests that insurance brokers have a duty to protect third parties from foreseeable harm flowing from the conduct of their clients. And so you can imagine why I've mentioned that. Insurance brokers don't have a duty to protect third parties from foreseeable harm flowing from the conduct of their clients. And I want to know how you square that holding with your professional negligence theory. I won't expect you to answer now. You say you're not familiar with the case, but
I'll try. I'll try real quick without reading the case. But I think the concept is that sounds like the client may have done something wrong, at least the quote you just gave us, and therefore preventing the professional negligence of whatever's happening in that particular instance is the problem. Here, the professional negligence is the understanding and the duty that they took on, that they voluntarily took on to provide notice of the claims. And that is enough to take us outside of the Mormon doctrine. And in fact, in a case that Aon cited, Pelham versus Greisheimer, which is an Illinois Supreme Court case, it's one where we've got an instance of attorneys in a divorce action. And the attorney was supposed to get insurance in the contract for the husband. It has to stay there. And the court, while they denied the claim of the children in that particular instance, saying, hey, we should have gotten the malpractice claim against the attorneys, the Illinois Supreme Court said the following: we believe a different situation would confront us if the complaint had alleged sufficient facts to show that the defendant had undertaken a duty to notify the insurance company or the husband's employer of the provision in the divorce decree. In that situation, the attorney may have had a duty to exercise reasonable care because his client and the plaintiffs, which were the children, herein could have justifiably relied on that undertaking. That's exactly what we have happening here, Your Honors, and that's at Pelham at 549. I'll reserve the rest of my time.
Thank you.
Thank you. Mr. Wilcox.
Thank you, Judge St. Eve, and may it please the court. Jason Wilcox on behalf of Aon. The common problem, as the court has picked up on, that cuts across all of Appellant's theories is that Clarendon was not Aon's client and had no business relationship with Aon. That leaves Appellant's contract claim on shaky legal ground because they cannot satisfy the very difficult standard for third-party beneficiary status. There's simply no agreement between Aon and SCB that expressly made Clarendon the direct beneficiary of a promise to notify SCB's insurers of any potential claims Clarendon might have. SCB asked Aon to notify the insurers to protect its interests, not out of some duty to Clarendon. And I think you can see that when you look at the 1999 letters, Judge St. Eve, that you were talking about. All the letters say is please put the underwriters on notice and obtain their approval if necessary for a standstill agreement, which would benefit all the parties because Clarendon at that point was in a dispute with another party in this reinsurance scheme, and they wanted to settle that dispute before there was any litigation between SCB and Clarendon. So of course, SCB is interested in doing that and wants to protect its interests. And you don't see anything in there that has the express language that Illinois law requires. There's no express provision that identifies Clarendon as a third-party beneficiary, and there's nothing that's such a strong implication as to be practically an express requirement, which is what this court has said was required in Coatney, and what Illinois courts have said over and over again is required to establish third-party beneficiary status.
Plaintiffs have submitted deposition testimony, affidavits from Radon supporting their claim that Radon and Aon had a contractual relationship and intended that Clarendon benefit. Why isn't that body of stuff enough just to create a fact issue?
Yeah, so two responses, Your Honor. The first is, I think the only thing they've really submitted is the Sheehan Declaration, which is at pages 486 to 87 of the supplemental appendix. And all that Mr. Sheehan says in his declaration is that they understood that Clarendon wanted Aon or wanted SCB to notify the insurers so that the insurance would be there. They don't show that there's any contractual agreement to put any duty on SCB to make that, which would be necessary here to have a third-party beneficiary relationship. And even if there was some understanding between Clarendon and SCB, there was no understanding between Aon and SCB that Clarendon was going to be any third-party beneficiary of that relationship. But more importantly, what the Illinois courts have said is that you need to point to express evidence of express terms in a contract to establish third-party beneficiary status. That was the Goldfarb decision from the Illinois Court of Appeals. And when you look at decisions like Carlson and Harleysville from the Illinois Court of Appeals, they say that things like surrounding circumstance can't substitute for express language in the contract. You need to have actual language in the contract that shows you that there is a third-party beneficiary relationship that's intended, and deposition testimony after the fact, declarations submitted decades later, can't substitute for that.
In '96, did Aon have any agreement with SCB as its broker? I know they sent the scope of proposal, and that's what's been the focus of the litigation here, but did they enter into any kind of a contract or agreement based on that scope of proposal?
I'm not aware of one that's been entered into, Judge St. Eve, and to the extent that one exists, I haven't seen it in the record here. So
Is that standard practice for the insurance industry? It just seems odd that there was a scope of proposal and no acceptance or agreement of agreeing to exactly what the terms would be.
So I'm not sure what standard practice, although what I will say, Judge St. Eve, is when I think about my own experience with my insurance brokers, when I go and get something like my auto coverage or my umbrella coverage, oftentimes I call them up, they get me insurance. We never sign an express contract between us. It's just kind of an understanding that they're going to work on my interest. But to the extent that there was a contract here, obviously that's a problem for appellants, not for us, because they need to be able to show express provisions in the contract that would create that relationship. And I think that if you want to look at something like the 1999 agreement, to focus on that again, the best you can say there is it's not a contract. At most, maybe it's referring and asking Aon to carry out some contractual duty under some contract that we don't have and we can't see. And you need, if you wanted to have a third-party beneficiary relationship, to look at the terms and the language in that agreement, which is simply not in the record. So that alone shows that not only is there not any express language that would make them a third-party beneficiary, but as you picked up on, Judge St. Eve, there's also just simply not a contract reflected in those 1999 documents. And the same is true for what they call the 1996 contract between Aon and SCB. So that consists of 3 documents. The first is what you were just referring to, Judge St. Eve, the proposal. The second is an insurance application, and the third is a confirmation that Aon sent to Lloyd's, letting Lloyd's of London, confirming that Lloyd's of London had underwritten the policy. If you look at the proposal, it really is just a pitch book. There's, for example, no terms there. It doesn't look like a term sheet or a contract. It's just, we're Aon, we're great. If you look at page 1 of that, it's just introduction to Aon. Page 2 of that document, which is at 109-13 of the district court docket, is why would you want to hire Aon in general? Aon then goes on and talks about its client list, and there's just simply no terms there. And most importantly, it's completely silent about third parties. It doesn't mention anyone like Clarendon, any class that Clarendon would belong to, and instead talks about how it can benefit SCB, to have a claims administration process that's good for SCB, create an insurance tower that would be beneficial to SCB.
But the 1997 documents that follow that 1996 proposal, you are right, it's a proposal, that, in the eyes of a reasonable jury, could seem like it's some sort of acceptance because it's Radon confirming that it purchased the insurance that Aon recommended. And so it's showing Radon accepting the offer on the terms outlined in that 1996 scope of work.
Well, so two responses, Your Honor. The first is, I don't think that there are any terms that you can accept in that 1996 statement of work. There's no, this is what we'll do, here's what the consideration will be, any of that. It's, again, just generalized, here's Aon, here's what we do. But even if you did want to say it was an acceptance, you'd still have the problem of there was no term that's in there that is, we will take on a duty to notify, and we will make your insureds, SCB, your downstream customers, a third-party beneficiary of any notice requirements that we may agree to between us. So even if you think that there is a contract that was created by the 1997 acceptance, and I'm assuming by that you mean where they appointed Aon as their broker, there still would be no third-party beneficiary under the very demanding standard, as this court has said in Quinn, where you have to have this express language. There's simply nothing in the proposal that has that. It's silent about it. The same is true of the confirmation that you can see at pages 311 to 13 of the supplemental appendix. It's completely silent about third-party beneficiaries. It says, here's where notice needs to go. SCB, if you want to tell Lloyds that you have a claim that you want to bring. It doesn't even say Aon has a responsibility to be the intermediary there providing the notice. And it's completely silent about any third parties, Clarendon, anyone else. So that can't create a third-party beneficiary either. And then if you look at the application, which is at 283 to 85 of the supplemental appendix, that does mention Clarendon, and that SCB is noting that one of its largest clients is Clarendon. But as the Illinois courts have said in decisions like Carlson, mere reference is not enough to create a third-party beneficiary. That's not the type of express provision that you need. And more importantly, that's an application that SCB submitted to Gulf, not to Aon. So to the extent that that's a contract and creating anything, it's creating a contractual relationship between SCB and Gulf, not between SCB and Aon that would impose any contractual duty on Aon. Although, if you look at 266 to 67 of the supplemental appendix, their own witness, Joseph Jacobs, admitted that the application was not a contract. And so I don't think that when you look at this, whether you want to think about it in terms of a contract or you want to think about it in terms of meeting the express requirements for a third-party beneficiary, there's just any evidence here that would allow a reasonable jury to infer that they had made something that rises to the level that you need to get to third-party beneficiary status, whether you look at the what they call the 1999 agreement, or you look at what they call the 1996 agreement. If we want to talk about the duty owed test, you're exactly right, Judge St. Eve, that no Illinois court has ever applied the duty owed test as something that's separate from the intent to benefit test. As this court said in Quinn, Illinois follows the intent to benefit test. Even if you want to look at section 302 of the restatement, as my friend on the other side references, the first thing that the restatement says is it's only appropriate if it will effectuate the intent of the parties, and then you go on to look at the intent to benefit test. Illinois has been very clear about how you decide whether the parties in their contract had an intent to benefit someone, and there has to be an express provision that identifies the third-party beneficiary by name or by class, or has such an overwhelming and compelling implication that it's practically express. In the words of Goldfarb from the Illinois Court of Appeals, it has to be express evidence of express terms. So that's not enough. And that differs. Illinois is different from a state like they cite, Minnesota, where you have cases like Twin City Construction, where it says there are two alternative tests. There's the intent to benefit test and there's the duty owed test, and you can satisfy either one. There's not a single Illinois decision that says that there's this alternative to the intent to benefit test, and it's the duty owed test.
Is that inconsistent with the restatement?
I don't think it's inconsistent with the restatement for two reasons. The first is because of that first sentence in the restatement that I noted, which essentially requirement one is you have to have an intent to benefit. And the second is the restatement then goes on to say there's two situations where you have an obligation. One is when it's to satisfy an obligation to pay money to the beneficiary. That doesn't sound like the duty owed test they're applying, because there's no obligation that Aon has here to pay money to anyone. It's about a notice requirement. And the second one is that the promisee intends to give the benefit of performance to the beneficiary. And Illinois courts have said that where you look to understand that intent is it has to be in the contract. That's the Zurich case from a couple years ago from the Illinois Court of Appeals. And the Illinois Supreme Court said that in the Resnick case all the way back in 1980. So for more than 40 years, that's been how you show whether there was any intent, whether it's by the promisee, by Aon, or by them combined to benefit. It's in the express language of the contract. And I think the best evidence in the duty owed test isn't some separate test they can satisfy, is their own case, Swavely, which is the only Illinois case as opposed to district court case that they cite in support of their duty owed theory. The first thing that happened in Swavely was the court said, we need to figure out if there was an intent to benefit, and it laid out all the standard intent to benefit principles that you see in every other Illinois case, the requirement that there's an express provision in the contract. It invoked the strong presumption that Illinois has that parties enter into contracts only to benefit themselves. And then only after it went through that and said, yes, applying the standard intent to benefit test, we see there was an intent to benefit the wife here. There, it was very clear because the contract said if the husband dies and his commissions haven't been paid, the wife will get the commissions. Then said, well, now we go on and we apply the duty owed test to see if whether the company can nonetheless back out of that and apply duty owed to decide, are you an intent, were you a donee beneficiary or not?
I'm still stuck on an earlier question, which is I know you referenced your own personal experience with your personal one-on-one insurance contracts, but how is Aon operating at this level? Worldwide brokerage, these are multi-million-dollar contracts, multi-million-dollar businesses doing for clients with no actual contracts.
Well, so I think Aon probably does have contracts. They're just not in the record for SCB. I mean, we can see a later contract that's in the record at Appendix 396, and there Aon expressly disclaimed that there be any third-party beneficiaries to the agreement. For whatever reason, probably because of passage of time, because this lawsuit was filed more than 20 years after the relevant events, we don't have that contract in the record here. But again, under the Illinois cases, that's a problem for the appellant. That's not a problem for Aon, because they need to be able to show that the contract exists. That's exactly what Illinois courts have said in decisions like Barney, where they said, if you don't have the contract, then you can't show that someone was a third-party beneficiary, because you need to be able to point me to express language that showed that there was an intent to create you as a third-party beneficiary. So
I assume that was subject of discovery and request for contracts.
I have to assume it was too, Your Honor, and I haven't heard any argument in the briefing from my friend on the other side that there was something, ill intent by Aon or that Aon intentionally withheld that, and I'm certainly not aware of Aon doing that in any way. So yeah, there's simply no contract here between SCB and Aon that shows exactly what the relationship was in terms of notifying anyone, and that means necessarily there's nothing showing that they had a contractual written understanding that Clarendon or anyone like Clarendon would be a third-party beneficiary of whatever notice, promises, or agreements that they had between themselves. In my last minute, let me quickly address the tort claim. So I am also unfamiliar with the case that you mentioned, Your Honor, but I will say it sounds very similar to this court's decision in MG, where MG also held that insurance brokers do not have an obligation to non-clients of the brokerage. And that's consistent with Illinois general law in decisions like Kopka, which was an attorney and an accountant, and the Pelham case, which my friend on the other side mentioned, which was an attorney, where the Illinois courts have been clear that you don't need to have, that generally professional negligence claims don't span to non-clients because you're not in a professional relationship with those companies, and you don't have that understanding. And the other problem for them is, of course, even if you thought that there could be a duty that was owed to non-clients, which would be expanding Illinois law, this court in Landmark held that there's no duty to provide, the brokers have no duty to provide notice of claims. The only way in which they can ground a duty to provide notice is through a contract, and if you're finding that duty grounded in a contract, then you're in the world of the economic loss doctrine, because that's exactly what the doctrine exists to do. So unless the court has any further questions, thank you very much.
Thank you, Mr. Wilcox. Mr. Luskin, you have a few minutes left for rebuttal.
May it please the court again. I wanted to address a couple different things raised by my colleague across the aisle here. First, this concept of there could be this mystery hidden contract. This, as Judge St. Eve asked, this was the source of discovery, and I think this concept is, it's an implied contract. They make a proposal, which was ultimately accepted by hiring Aon to broker policies, and they got paid commissions. It's pretty simple. And it happens all the time, and I don't know if they have other agreements. I think this 2001 agreement that my colleague on the other side mentioned was a special agreement to deal with certain things because claims were going so nuts at that point in time. But before that, we had a proposal that was accepted. And my client, Joe Jacobs' statement that a proposal is not a contract, all by itself doesn't mean anything. If a proposal is ultimately accepted, well, then it becomes a contract. And in fact, the proposal itself talks very specifically about duties that Aon's going to take on. At docket 109.13 at 10, it states, building an efficient and effective claims management process begins with a solid foundation. That foundation begins with the day-to-day claims management role, which is assumed by our brokers for each of their accounts. That's very clear language that they're taking on this claims management role, and ultimately we get to the concept that when they're in that role, they get asked to provide notice, and they fail to do so, and it should have benefited Clarendon. On the 302, money is not a requirement, as my colleague said, for 302 to apply. Again, one of the examples is number 5. C is a troublesome person who is annoying. A dislikes him, but believes the best way to obtain the freedom of annoyance is to present a gift, and he gets a gift of cigars to just pacify him. And if the person is discharging the duty of providing the gift, that's enough, again, to make an intended beneficiary here. I see I'm out of time. Thank you, Your Honors.
Okay.
Appreciate your time.
Thank you, Mr. Luskin. Thanks to both counsel. The court will take the case under advisement. The next case for oral argument this morning is United States versus Island, appeal number 24-1528. Good morning.
Good morning, Your Honors. May it please the court. My name is Anna Bussey, and I represent the defendant appellant Antoine Island in this case. This case, at its core, is about protecting a defendant's Fifth Amendment right not to testify or put on a defense by ensuring that juries do not improperly consider that decision and by ensuring that the government does not improperly invite juries to do so. This court should find in favor of Mr. Island for 3 reasons. First, because at least one juror took the government's improper invitation to consider Mr. Island's decision not to testify as evidence of his guilt, Mr. Island was not afforded an impartial jury in this case. Second, the indirect comments at closing argument that invited the jury to do so violated Mr. Island's Fifth Amendment right not to testify. And finally, the evidence presented at trial was not sufficient to convict Mr. Island of the charges alleged. First, Mr. Island is entitled to a new trial, or at a minimum, to an evidentiary hearing. This is necessary to ensure that Mr. Island had an impartial jury at trial. Defendants are entitled to an impartial jury that determines guilt based on the evidence presented at trial and based on the court's instructions, and Mr. Island was afforded neither here.
Ms. Bussey, we addressed a similar situation in Torres-Chavez, and we're very clear in under 606B about what you cannot inquire into in terms of jurors' communications during their deliberations. Do you need, in order to avoid Torres-Chavez, do you need this extraneous prejudicial information or outside influence? So in other words, if we don't agree with you about outside influence or extraneous prejudicial information, do you agree that this case is governed by Torres-Chavez on that issue?
Yes, Your Honor, I do. In Torres-Chavez, there was no evidence or allegation of an outside influence at issue here, and as Your Honor knows, in that case, it was determined that the court could not inquire into the jury's verdict. Right. That was an internal juror process that under 606B2 is not allowed, but we have a different factual scenario here.
And your argument here is that the comment the prosecutor made during closings is what is the outside influence. Is that
Yes.
correct?
Yes, Your Honor. We would argue that the prosecutor's improper comment during closing argument, because it's not evidence and because it was improper, is an outside influence that should not have been considered by the jury.
So if we find that comment was proper or not erroneous, then your juror argument fails as well.
The court need not find that the comment rises to the level of plain error to agree with us. So that argument on the Fifth Amendment violation is at plain error because it was not objected to at trial. But the court does not need to find that it rises to that plain error standard to find that it still constituted an external influence.
If we find it's proper, would you agree that you're governed then by Torres-Chavez?
Yes, Your Honor. If the comment is determined proper in the sense that there was nothing wrong with the government saying there's no answer here for all the evidence we put on at all and the defendant did nothing here, then I think the case is governed by Torres-Chavez because there is no way to get past that 606B bar in that case.
What's your limiting principle on that? It seems like, based on your argument, any comments that are made during trial could constitute this outside influence, which would really swallow up Rule 606B and how we've interpreted it.
Yes, Your Honor. So the limiting principle here is that the 606B2 inquiry should turn on whether the prejudicial information or influence came from outside the trial evidence and outside the jurors' internal deliberations. So if you have an instance where something is part of the presentation of evidence and something goes wrong, as Your Honors know, there are ways to address that. But
So
here,
any closing arguments?
Any improper closing argument after the close of evidence that presents an issue like here where there's an invitation to consider the decision
What about
not to
opening
testify.
statements?
Opening statements would be similar. They're before the beginning of evidence. If there's an improper comment there, they're not considered evidence under this court's jurisprudence.
What about a comment made during the course of the trial where the prosecutor's trying to get certain evidence admitted and makes an improper statement there?
That's a closer question given the line that we're drawing, but the court need not reach that distinction here because here we're worried only about an improper comment at closing argument. And that improper comment we know impacted the jury because we have a juror's statement from after trial that said that the juror considered Mr. Island's decision not to testify as evidence of his guilt. He thought he would have testified if he wasn't afraid of being found out as the person in the videos. So here where we have that comment from the juror, we know the juror took this improper step, and we combine that with the prosecutor's remarks during closing argument. We have a stronger case here that allows the court to draw a more narrow line that would still ensure that Mr. Island's Fifth Amendment rights are protected without, I think, falling into the snowball issue that Your Honor mentions. And indirect comments on failure to testify made during closing arguments are best understood as external influences for a couple of other reasons. So if we look at this court's jurisprudence on internal influences, those things are things like whether a jury is drinking during trial or they didn't understand instructions or the kind of case at issue made the jury feel afraid. And the prosecutor's closing arguments don't fit well into that bucket. Instead, they fit better into the external influence bucket with cases like Vasquez-Ruiz, where a juror found the word guilty written in her notebook, or in cases like Weishart versus Davis, where the jury found out as they were preparing to begin trial that the defendant had taken a polygraph test. Those kinds of things are external influences, and the prosecutor's closing argument here fits better into that bucket. And the prosecutor's comment was improper under this court's jurisprudence. The prosecutor's comments were an impermissible indirect comment on Mr. Island's decision not to testify because
And you do agree we're reviewing that for plain error, correct?
Yes, Your Honor, we're reviewing that for plain error. And those comments were improper because they fall in the same bucket as this court's jurisprudence that has found comments that evidence was uncontradicted, unrebutted, or here functionally unanswered are not proper. This test comes from a case called Cottenham. Indirect comments on a defendant's failure to testify violate the defendant's rights when they were manifestly intended to refer to the defendant's silence or when they are of such a character that the jury would naturally and necessarily take them to be so.
Why weren't those comments invited under our case law, given the defense lawyer's comments its closing about the missing evidence. Or you spent quite a bit of time about what isn't there, and that we have said a proper rebuttal is, well, let's focus on what is there.
That's true, and in cases like Gustafson, where the court commented on a particular piece of evidence, no one got up and told you where the money came from except our witness that said it came from this place. That's the case. But here, where a government arguer gets up and says the defendant had no answer for anything at all that we put on, those kinds of comments are of a different character, and they put the onus on the defendant to testify and to bring that evidence forward.
In other words, could the government have made the same point without the conjunctive? In other words, let's focus on what we did supply without adding the second part. Defendant hasn't supplied any answers.
I think that would be proper under this court's jurisprudence if the government said, here's exactly what we did. We had A, B, and C that supported our case, but that's not what happened here. Here, the government said Mr. Island had no answer for anything that we put on. And I take your concern that that's often a subject of rebuttal.
Counsel,
but not...
I'm actually looking at the transcript at 6:51. And what the government said was, quote, so you focus on the evidence that's before you. Right?
Yes.
They didn't enumerate it, but they did say focus on what's before you. And he goes on, or she, and I get why Mr. Boyle focused on what there wasn't, is because they don't have an answer for what there was. So that's not enough
I think
to
without...
be a rebuttal, right? It's very close. It's like 2 lines above.
Yes, I think
Yeah.
without that second part, that they don't have an answer for what there was, then there might not be a concern here. But that language very strongly puts the responsibility on the defendant to have had an answer. And the Fifth Amendment protection against self-incrimination that we hold very dear in our criminal justice system means that that's not the case. So I agree, right above there's some language that is proper, but the fact that there's proper language doesn't negate the fact that there's also improper language here.
Okay, but on the page before, the government references Mr. Boyle's talk, there's no cell phone, there's no recorded funds, so they are talking about, it is a rebuttal to what Mr. Boyle is saying, right?
Those comments are, yes.
And that comes right before they don't have an answer for what there was. So I'm just trying to figure out where to draw the line, because this is very close in time, perhaps 30 seconds, if not shorter.
Yes, Your Honor, I see that the timing there is distinct, but the comment itself, the timing doesn't change the character of the comment, and the character of the comment here differs from other cases where the government is commenting on particular pieces of evidence at issue. Instead, this comment is broad and sweeping. There's no answer at all for anything that we put forward.
But the timing does change the character of the comment when you look at it all in context, which is what we're supposed to do.
I disagree, Your Honor. I don't think it changes the character of the comment.
But our case law is clear that you look at it in the context of the closing and what you've said around it. And so I think it does change the character. Maybe not in all cases, but I think it does change the character.
Perhaps in some cases it would. Here, I would agree to disagree with you on that. To put the onus on the defendant to come forward and have some kind of answer implicates the defendant's Fifth Amendment right, and it matches the court's prior decisions here that find saying evidence was unanswered, uncontradicted, or unrebutted is not proper. And I see that I'm in my rebuttal time, so if there are no further questions.
Okay.
Thank you.
Thank you. Mr. Coluri.
Good morning, Your Honors. May it please the Court, Prashant Coluri on behalf of the United States. The judgment against the defendant, Antoine Island, should be affirmed. First, the evidence at trial was more than sufficient for the jury to find that the defendant was the individual who twice sold crack cocaine to a government cooperator. Among other things, the jury heard from multiple witnesses who identified the defendant as the crack dealer. That witness testimony was corroborated by footage of the deals. There were also screenshots taken from that footage that the jury was able to compare to defendant's driver's license photograph, as well as their observations of him at trial. And there was also recorded telephone calls and text messages that the jury was shown. Now, the defendant claims that that evidence was insufficient and attacks part of each witness's testimony as well as the clarity of the footage. He made those same arguments at trial. The jury rejected them. This court should do the same. Questions of witness credibility are reserved for juries unless one of two exceptions applies, neither of which is present here: that the testimony was physically impossible or that it was impossible by the laws of nature.
Can we skip to the rebuttal close?
Yes, Your Honor.
And what we were just discussing with Ms. Bussey? When the prosecutor says the defense focused on what was not in evidence because they don't have answers for what was, do you think it's possible for a juror to believe, based on those statements, that Island should have answered or challenged the government's evidence?
No, Your Honor. I think the context of the rebuttal argument is very important here. First, and I know appellant attempts to attack this, but at the beginning of the rebuttal closing argument, the government notes very clearly, while it refers to the district court's statement during jury selection that both sides start at zero and there is no head start, immediately after that, government counsel notes that it is the government that has the burden of proof.
You know, let's go back to that too, because I agree with you. The government notes a couple of times that the government has the burden of proof. As for this zero thing, it looks to me like the court, when it makes that statement a couple of days earlier, before voir dire even begins, it's making a different point about zero than the government does a few days later in its rebuttal close at the end of trial. So when you look at the voir dire transcript, and I'm searching for it right now, the district court is telling the jurors, don't look at news coverage, put away your phones. You know, the only thing that matters is what's happening in this courtroom. This case starts at zero with you, okay? That seems to me to be a different point than what the rebuttal close, the statement in the rebuttal close. Both sides start at zero. Can you comment on that? Here we go. She says, okay, I found my notes, thank you. She's saying, you know, don't have your phones, don't look up anything about this case or participants. This is the only way they can get a fair trial. Understanding all of that and understanding that this case should be at a 0 point with you, no one should have a head start, I'm going to ask you to be sworn. Then we get to rebuttal close and you know exactly what the statement was.
Yes, Your Honor. I think it's referring to that, and the reason I say that is because what the point that was trying to be made during rebuttal closing is that the jury was coming in kind of with a blank slate, not knowing anything about the case. And I think if this court were to find that that statement was inartful, I think it gets fixed right after that, because the immediate statement after that is the government has the burden of proof. And then government counsel goes through the various parts of the evidence showing that the government has met its burden of proof. And then we get to the remarks that are now being challenged on appeal, which is addressing defense counsel's arguments. So after addressing the evidence that was before the jury, including the multiple witnesses, footage, etc., we then get to missing evidence, and government counsel there notes that, of course, defense counsel is going to focus on missing evidence because they don't have an answer. Defense counsel doesn't have an answer for what the evidence before the jury was. And so they're going to focus on cell phone contents or the lack of the buy money or the fact that there was no cell phone location information. And government counsel was noting that even if some of those things were there, defense counsel was going to focus on, would find some other missing evidence.
In McKetsey, we sent back language where the prosecutor talked about uncontroverted, unchallenged, unrebutted. Can you explain to me the daylight you've seen between no answers in those terms? And is the daylight, in your view, well, let me just ask that.
I think the daylight, or the gap there, Your Honor, is that the government was not saying that the defense or defense counsel didn't have an answer to the evidence that was presented before the jury. It was that that defense counsel here was focused on missing evidence because they didn't want to address the information that was being put before the jury. I think this court has repeatedly held that remarks in response to a defense counsel argument or a criticism of defense's tactics, which is what I would argue is probably most on point here, is it was a criticism of how defense counsel was approaching this by focusing on missing evidence instead of the evidence before the jury, that is not improper and that is allowed as rebuttal, and at the very least is not plain error when defense counsel doesn't object during closing argument. And then, Your Honor, I would note that even if this court were to find a problem with it, the second part of it is that the defendant here would have to have been deprived of a fair trial. And that's not the case here. This was one sentence over a multi-day trial that did not draw any objection from defense counsel, and it was cured by jury instructions about the burden of proof, about defendant's right not to testify, and for that to not even be considered, and that the attorney's statements are not evidence. And of course, there's also the overwhelming evidence here, as I previously summarized. Which brings us to the third point, which is the juror comment. The district court correctly held that the juror comment, that a new trial or evidentiary hearing was not required based on the juror's post-verdict comments. Those comments were inadmissible under Rule 606 and did not warrant further inquiry because they reflected the juror's internal thoughts only. Importantly, there was no reference here to any kind of outside influence from the juror's remarks. The juror also, and I think there's a leap here that the defense takes on appeal, which is the jurors from the remarks didn't say that he actually held anything against the defendant. The juror made a remark afterwards inquiring on whether he might not have testified because he didn't want to hear the voice being matched from testimony to the recordings, or if he didn't, and this trial took place during COVID, if he didn't take down his mask because he didn't want the jury to have a clear view of his face over a multi-day trial as they were watching the footage and the screenshots of defendant through
Mr.
other
Brewer,
witnesses.
do you recall how many people were masked in the courtroom? Was defendant an outlier in having a mask on?
I don't think this is in the record, Your Honor, and I can only answer based on my memory because I was the trial counsel. I believe defendant was the only individual that was masked. There might have, actually, you know what? There might have been one juror who was masked because she was pregnant.
Okay.
What year was the trial? Was it 22 or 23?
I believe it's 2021, or it's possible it was December 22, Your Honor. I can't,
Okay.
one of the two.
2022.
2022.
2022, sorry.
And let me ask you this. You know, we were discussing with Ms. Bussey Island's position that the prosecutor's comments were an external influence and therefore would be within an exception for 606. I don't see your cases ruling that possibility out definitively. What case can you point to? Because the cases you've given us don't do that.
I think
say that, you know, that cannot be.
Yes, Your Honor. I think the case law on this is pretty sparse. I don't think that what happens within a trial proceeding is what the rule had in mind. And I say that for two reasons. First, in terms of what I believe to be the best case, I think it's the Stewart case, which is a Second Circuit case, which describes outside influence as, quote, outside contact, outside communication or publicity, or information that's entered into the jury room through some prohibited route. I don't think closing arguments, and again, I know Your Honor asked some questions about, you know, whether a poorly worded question or an opening statement. I think in those scenarios, you have judicial protection of a defendant's right. So I don't think that's what the rule implies. The rule implies scenarios where the judge isn't there to police what's going on. In this particular instance, if there was something this couldn't be considered an outside influence because the judge was present. And so the judge could either rule on an objection if an objection had been made, sua sponte inserted herself into the proceeding, and if something, proposed a curative instruction, or if something happened that was so outlandish, could have declared a mistrial. But again, the judge is there to police things in a scenario like closing argument, opening statements, questions that a lawyer might pose during a direct or a cross exam. That's not what Rule 606 is focused on. Rule 606 is focused on how information that gets to the jurors in a way that is not in the presence of the judge.
You said the best case is Second Circuit and Stewart, but it sounded like you were also about to tell us about another case that you thought could shed better light on your position.
I think Stewart is the best case, Your Honor. I would only say that the other cases are instructive in the sense that all the other cases that I think, frankly, both sides cited showed there was nothing where an external influence was held to be anything that happened during trial. It was bailiff notes. It was finding out about outside of trial about a polygraph examination of a defendant that was never referenced during the trial. It was the guilty note that was scribbled on a juror's notepad. It was a newspaper article about the defendant that was put into a juror room. Again, all of these situations are happening outside of trial. But then
you've argued that the defendant forfeited this argument. In reply, Mr. Island cited Otradovic. How do you respond to that? Since that was you didn't get a chance to respond to that.
Yes, Your Honor. I think Otradovic is distinguishable here. Otradovic was a situation where there was a slight nuance between what was stated in the lower court and what was stated on appeal. The issue there was whether the defendant had the ability to pay a special assessment. I believe it was a child pornography case. And at the lower level, the attorney said, the defense position was, well, the defendant wasn't subject to or shouldn't be subject to a special assessment because he spent all his money on an attorney. And I believe on appeal, it was a slightly nuanced argument, which was he was eligible for appointed counsel. So I think in a nuance like that, it's fine. I think in this particular instance, the defendant is asking this court to consider an external influence, a purported external influence, the closing argument, that was never raised to the district court before. Importantly here, the juror comment was disclosed to the defense counsel. They filed a motion for a new trial based solely on the comment. The government responded saying, this is purely internal. There's no external influence being alleged. And then on reply and at the hearing, defense counsel at the district court level said, well, the only thing they identified was the comment on its own evidenced racial bias. And the district court put a kibosh to that. There was nothing about closing argument. And so for defendant to now raise that for the first time on appeal does a disservice to the lower court proceedings because the district court could never consider it. And that's why we believe the argument is forfeited, if not waived, in that scenario. I would simply note, Your Honor, that at the end, that even if the juror remark could be considered as an outside influence, on its own, it's still not enough because the juror did not connect anything that he considered to the government's closing argument. And there needs to be some connection there because if not...
But if it was an outside influence, shouldn't a hearing have been conducted?
If it was an outside influence, right. Yes, it should. And if the juror had said, if the juror had said, because of what the government said, I started considering this, that could be a that I think would lead to a scenario where further inquiry was needed. But that's not present here, and so we'd ask that the judgment against the defendant be affirmed. Thank you, Your Honor.
Thank you. Ms. Bussey.
I'd like to start with the government's argument that the evidence was overwhelming here, and I think that's a mischaracterization, to say the best. The evidence presented at trial to identify Mr. Island as the individual known as Black was not overwhelming. So even on a plain error standard where we are on that Fifth Amendment issue or at harmless error, These evidentiary issues are significant enough to indicate that these errors require reversal. So, for example, the videos referenced by the government don't show this individual's face for more than a second. In one of them, it's only in profile, and in the other, the top half of the individual's face is obscured. Special Agent Ramos, when identifying Black as Mr. Island, attempted to do so having never met Mr. Island, never met Black. His only familiarity with Mr. Island was through a driver's license photo.
What
And
about the confidential informant's in-court identity?
The confidential informant, as we know, has ulterior motives and biases at issue, but beyond that, which
wouldn't that require us to reweigh the evidence? If the confidential informant himself, during the trial, said, Mr. Island, that's the one, for us to overturn that would be really stepping outside of our precedent and would be putting us in the place of reweighing and finding that CI not credible.
on the sufficiency of the evidence issue, perhaps, but when we turn back to the idea of the errors being harmless or not plain, that kind of issue is something that the court can take their authority to look at the whole picture. And here, Mr. Villegas, the confidential informant, claimed to have met the individual Black on a timeline that was impossible, provided a very short description that was only height, gender, race, and the fact that he was wearing diamond earrings. And from there, we have a lack of credible evidence to connect the phone number at issue to Mr. Island. The contemporaneous report was not preserved nor presented at trial, and a report run 5 years later produced only an 86% chance this number belonged to Mr. Island. And then you have Ms. Robinson, the final person to identify, allegedly, supposedly, Mr. Island at trial. But when she was initially interviewed, she named 2 other individuals first. Then she said she couldn't identify the person in the video, and only when shown a subpoena with Mr. Island's name on it did she say, yes, that's him. And these kinds of holes in the evidence are enough to indicate that the errors complained of here are not harmless. There's a chance that these things took Mr. Island's Fifth Amendment right away. And I think to the point made earlier that an evidentiary hearing is the proper way to determine the errors at issue here, whether they happened. That is what we should do here, because although it's true that the juror didn't say to the judge at the time, I considered this because the prosecutor during closing argument said maybe that I could. At an evidentiary hearing where we could ask the jurors how they reacted to that comment, we might be able to determine that that was the case. There's certainly a reasonable probability that that was the case. So here, where we have this evidence that we can't ignore that a juror may have considered Mr. Island's exercise of his Fifth Amendment right, an evidentiary hearing, I think, is really proper to make sure that we protect that right. If there are no further questions, we'll ask that you find in favor of Mr. Island. Thank you.
Thank you, Ms. Bussey. And Ms. Bussey, you and your firm have accepted a court appointment for this case. Thank you for doing so, and thank you for your strong advocacy on behalf of your client.
Thank you.
Thanks to you, Mr. Clory, as well. The court will take the case under advisement. The next case for oral argument this morning is Murphy versus Roundy's, appeal number 25-1741. Good morning.
Good morning, Your Honors. Attorney Shannon McDonald on behalf of Plaintiff Appellant. May it please the Court. Your Honors, this is a ADA FMLA case. The Plaintiff Appellant, Miranda Murphy, was employed with Roundy's company from March of 2020 through July of 2022. She was a driver, a truck driver, full-time. At all times throughout her employment, she suffered from various mental disabilities, including PTSD, anxiety, depression, and ADHD. Ms. Murphy takes medication, always has taken medication for mental disabilities. At one point during her employment, she consulted with her manager, Daryl Grant, concerning her disabilities and her need for some type of accommodation. At that point, and it was in the fall of 2021, Ms. Murphy recommended or asked for potentially becoming a regular driver instead of a spotter, possibly a change in her job duties or her schedule as possible accommodations. Nothing happened following that meeting. She met with a new manager in April or May of 2022, and that was Mr. Sadowitz. Similar conversation with Mr. Sadowitz where she explained, I have mental disabilities. She referenced those disabilities, indicating that she could use an accommodation to help with her job. There was then a change in her medication in June of 2022, which resulted in another meeting with Mr. Sadowitz in June of 2022. That change in medication affected her ability to sleep, and so she was groggy in the morning, and so when she met with Mr. Sadowitz in June of 2022, she explained this to him and asked if there was some type of accommodation, such as possibly a later start time, or again, a change in her schedule. At all times when she would bring these matters to the manager's attention, they would refer her to the HR department. They didn't engage her and speak with her about her disabilities or ask any questions about that or her job duties and what might help her. Instead, they just referred her to HR.
When she gets to HR, and I know that you have some disagreement with Roundy's about the nature of her request, but assume we believe the facts in the record show that she requested an FMLA accommodation from HR. Is it your request, is it your contention that we should construe her request for FMLA leave as a request for an ADA accommodation?
Yes, I think you can.
And what's the authority for that?
Sure, and I think that falls under Bultmeier and Beck. Both cases involve individuals with mental disabilities, and especially in Bultmeier, the court went and explained how an employer, they need to be more proactive in the interactive process. And they say that just employees aren't expected to know the magical words that I need an accommodation, especially when the employer is already on notice that the employee suffers from mental disabilities. In those particular circumstances, the employer has to go a step further. And so then a request for FMLA leave certainly can be seen as a request for some type of accommodation that would then trigger the interactive process.
Is there any risk there, from your perspective as counsel for Ms. Murphy? Ms. Murphy goes to HR and says, I'd like FMLA leave. Let's assume we think the record shows that, and that's all she says. And then HR comes back and says, have you thought about a change in schedule? Have you thought about shifting down to yard spotter duties only or driver duties only and not also yard spotter duties? Have you thought about this? Have you thought about that? Is there a risk that to Ms. Murphy, it's as if the employer is actually pushing her away from FMLA leave, or not a risk at all?
I don't believe there's any risk at all. And again, I believe that an employer, and here Roundy, should have gone that extra step because they were aware of her mental disabilities. Again, depression, anxiety, ADHD, PTSD, they knew she suffered from these things. And so I think they should have gone the extra step, and I don't think it would have chilled her rights under FMLA or anything of the sort. They had an obligation to sit down and actually have that conversation. I think that's why the court in Bultmeier and Beck are so persuasive here, because they use that exact language where when you have an individual such as Ms. Murphy with mental disabilities, and she's expressing to you that there is some type of issue going on with her disabilities and she needs some type of accommodation, you have to then sit down and speak with the person. Again, Bultmeier and Beck say that specifically.
One counsel, because if we assume that she asked for FMLA leave and there was an interaction and she filed with MetLife, what is your contention that during that meeting, that I know HR disputes that it happened, but at that meeting, HR should have discussed other accommodations even though she was asking for FMLA leave?
Yes, and I think the record isn't abundantly clear on what exactly she said during that meeting. And Ms. Murphy certainly admitted that it was a while before. Obviously, she doesn't remember exactly what was said, but that she does know that she brought up her medical conditions in her request for FMLA leave. So I would say yes. During that meeting especially, it should have been brought up, or at least a discussion about what is going on here, what do we need to do, or what's going on with you, how can we help you? And I think that's what Bultmeier and Beck both point to, is when an employee like this with mental issues comes to the company seeking something, some type of accommodation or here leave, there is an additional obligation on the company not to just take everything at its word, FMLA, which she was told to do by the managers of the company as well.
The
And that-
plaintiff in Bultmeyer didn't quite ask with specificity that the record suggests here that Ms. Murphy asked, and that is something that Roundy's brings up. So can you address that, because you've asked us to look at that case, but it may be that they're not really similar plaintiffs in that regard.
No, and I think it actually makes it even stronger in this case, because in Bultmeyer, the employee just simply said he wasn't equal to the task and then didn't show up for a physical. And the employer then terminated that employee based upon those two items. And here, at least, we have Murphy, who has made the initiative to speak about her mental disabilities and request for accommodation, and then going to HR to request some type of leave for an accommodation. So I think it's even stronger
there
in this
was
case.
evidence that the mental health conditions interfered with the ability to ask for certain things, and I don't see any evidence here. So are you asking us to hold that any time an employee says that she has mental health obligations and asks for FMLA leave, that there's an obligation on the employer to say, well, hey, what about these accommodations?
I do believe that there should be more of an affirmative obligation on the company to at least delve into what is going on.
Anytime that an employee just says, I have mental health issues, that should be sufficient to trigger it.
I believe if there's an affirmative assertion that there are mental health issues and that employee is at the same time seeking some type of leave or accommodation, there should be a more robust discussion concerning what those disabilities are, what are the job duties, and how can we help. And maybe FMLA is the answer for that particular case. But as this court has made clear, a lot of times it's not, because a lot of times they're putting these employees on FMLA where it's an excuse to not work, as opposed to an accommodation so that employee can continue to work. So going back to the initial question from Your Honor regarding Bultmeyer, again, I believe this case is even stronger in that, especially with Bultmeyer, the doctor submitted a letter after the termination already occurred. Here we have Murphy, who's already expressed during her employment several times to managers and HR that she's suffering from these medical conditions. And I would say...
What's the evidence that she told HR that several times?
There's not, and maybe I misspoke,
I know
but
she
no,
told
there's
some
not.
supervisors before, but I didn't see any evidence that she
No.
raised that with HR.
You are correct. There was one conversation with HR, and that was June of 2022 with Ms. Robinson. The other conversations that I was referring to were the conversations with Mr. Sadowitz and Mr. Grant.
Who told her to go to HR?
Who told her to go to HR. Again, no interactive process with them. It was just go to HR. And with respect, again, to Bultmeyer submitting a doctor's letter after the fact, the court there said, okay, so then when you get that information after the fact, that was a perfect time for you to then maybe come back and review this situation. The same thing happened here, where after the fact, Ms. Murphy communicates, because then she was ultimately approved for FMLA leave.
So when does the ADA accommodations process end? Because it does seem that you're suggesting on Bultmeyer and on the facts here that even after they fired her, 2 weeks later, Roundy's had an obligation to pick up or resume the iterative process.
Sure.
When does it end?
And I think there would have to be some type of close temporal proximity to when that happens. In Bultmeyer, it was the same day. Mm-hmm. Here we're talking about a couple weeks where the additional information comes through. And I would also say, and this goes to our other arguments on the other points as well, with MetLife being the third-party administrator, contractually with Roundy's, they're using MetLife as a sword and a shield. So I would say anytime MetLife is receiving this information from Ms. Murphy, really it's Roundy's receiving that information at the same time. But to straightforwardly answer your question, there would have to be a temporal proximity, a close one. 6 months down the road, new information comes in, that might be too long. But here, with just a couple of weeks that go by, again, back to Bultmeyer, they say, and back, all you had to do was sit down with the employee. And they specifically state This would have been the proper way to engage in the interactive process. And that was the court in Boltmeyer speaking to receiving information after the fact, after the termination has already taken place, but revisiting it because this new information came to light. And so for those reasons, under the interactive process, our position is the district court erred. It determined that Ms. Murphy caused the breakdown in the interactive process. And I believe with the evidence and the facts that have been presented, there is overwhelming evidence showing that she was driving the interactive process. The only thing Roundy's said in response was, go on FMLA.
You're into your rebuttal time, if you want to save.
I'm
save
sorry.
it.
Yes, I will
It's up to
save
you.
I will save the remainder. Thank
Okay.
you, Your Honor.
Ms. Pfeiffer? Good morning.
Good morning, Your Honors. May it please the court, my name is Sally Pfeiffer, and I represent the appellee, Roundy's Incorporated, with respect to this appeal. It is our position that the district court properly granted summary judgment on all of Ms. Murphy's claims, her 2 ADA claims and her 2 FML claims. And we believe that the court should affirm the dismissal of those claims. The first claim that Ms. Murphy brings is a breakdown in the interactive process with respect to the Americans with Disabilities Act. First, I want to make it clear that there is no independent cause of action for failing to engage in the interactive process. And both the employer and the employee are responsible for interacting together within that process. And in the in the Igasaki case, this court said liability can only arise when the employer's failure to engage in an interactive process resulted in a failure to identify an appropriate accommodation for the qualified individual.
I have a similar question for you that I asked Mr. McDonald about when the interactive process ends, because Mr. McDonald makes the point, sure, Roundy's fired her, but its third-party contractor was still processing her FMLA. Of course, she turned it in late, and that's why. And that comes to light, that they finished it now, they've done this retroactive decision, her leave has been approved retroactively. Why should we hold that under those circumstances, Roundy's can act like, when it's their own third-party processor, the process should end and they should not consider, this new information, which is close in time. It's not the same day as in Boltmeyer, but it is just 2 weeks later.
Well, I think that the distinguishing factor in this case is that Ms. Murphy was given the opportunity to provide medical certification to support her FMLA. She testified in her deposition, she knew she had 15 days to supply the employer with that certification. She failed to do so. She then received a letter on July 6th from from MetLife telling her that her FMLA had been denied and any further leave after that point was not going to be protected. Despite receiving those communications, she was absent on several additional days. While she called in, I admit that she called in to report her absences, she never indicated what those absences are for.
Why then does Roundy's not call MetLife and say, hey, we fired this employee, do nothing further, close her file?
And I think that's an issue that's not in the record. If you're asking my opinion, I think it's sometimes, right, HR people get involved with the day-to-day on what's going on within the plant, and there isn't that communication with MetLife. I don't know what the reason is in this particular case. It's not in the record, but that would have been an issue for Mr. McDonald to have appropriately discovered during the course of discovery. So I think that's the difference here. If you allow an employer, if you take the position that the accommodation process is ongoing, there's no end. There's no reasonable end. And Judge Posner said that in connection with the Townsend case, that really relates, I guess, more to the FMLA claims that are present. But the same analysis, in my opinion, applies. Employers make decisions, and you can't allow those decisions to always be retroactively made. And I think the Bultmeier decision is factually different than what was present in this case.
Counsel, should plaintiff have pled failure to hire or rehire under the ADA?
She didn't apply for rehire, so I think that
Well,
would not have been...
Yeah, but would that have been a solution? Because we're wondering where you end on the failure to accommodate. Is the answer she should have brought a failure to hire or rehire?
Well, she brought a termination claim, right? So her termination claim is that she was terminated because of her disability. And we know that in the Seventh Circuit, you have to prove it's but-for analysis. And there's no evidence that her employment was terminated because she was disabled. Her employment was terminated because she failed to supply the medical certification that was requested by MetLife. She was notified on July 6th that any further absences were not going to be covered by FMLA, we're not going to be authorized, and yet she continued to take leave. She could have, for example, called in and said, hey, I'm working on it, I'm struggling, I'm trying to get this med certification, my doctor can't respond, but she didn't provide that information. My counsel across the aisle indicates that Ms. Murphy was in constant contact or continuous contact with MetLife. That allegation is not supported anywhere in the record. The contact between Ms. Murphy and MetLife is MetLife sending communications to Ms. Murphy. There's no evidence either in her deposition or in any post-deposition affidavit saying that she was in contact and this is the information she was relaying to MetLife so that MetLife knew, right? So MetLife made a decision based on the information it had. The company made a decision based on the information that it had. And unfortunately, this is one of those situations where there was no communication between the two. But the issue again is, was Ms. Murphy terminated because of her disability? And it's our position that there's no evidence to support that. There's no pretext. The company did not lie about its decision. It didn't, there's no evidence that it treated other individuals more favorably who had requested FMLA, for example, and the accommodation process has to have some stopping end. And when the employee...
Did all requests for FMLA leave have to go through MetLife? Is there any evidence otherwise?
Yes, all communications about FMLA were directed through MetLife.
And is there any evidence about why Ms. Murphy waited until roughly 3 days before the deadline to send the form to the doctor? I didn't see anything, but you know the case better.
Yeah, no, there's no evidence in the record that would explain why she failed to provide that certification form to her doctor until 3 days before the deadline.
You started to talk about pretext. I want to back up there. Ms. Murphy is drawing our attention to her conversations with Sadowitz, okay, as her supervisor, and says, hey, I told him I had these disabilities. And I'm gleaning that your position is his testimony is irrelevant for the pretext, determining whether their reason for firing her is pretextual because he didn't play a role in the decision to terminate Murphy. But if we are to draw all reasonable inferences in Murphy's favor, why couldn't we conclude that he at least nominally participated in the decision to terminate her since he signed the termination letter?
Because the issue is, and this is in the, I'm going to not pronounce it correctly, Kravny versus Limagrain Genetics Corporation. So in that case, this court said that a supervisor's alleged inconsistent statement cannot create an inference of pretext where there is nothing in the record to suggest that the supervisor participated in the decision to terminate. In my opinion, I'm actively participating in the decision. I'm having a discussion with HR about whether this person should be terminated. Sort of like that cat's paw analysis. Here he simply signed the letter and sent the letter to Ms. Murphy. That's not really participating
We don't
in
have
the
a
decision
fact
to
issue on
terminate.
that?
Pardon me?
There's no fact issue there where he signed it. We have a letter he signed. And Roundy says, oh, he signed it, but it doesn't mean he was involved. And Ms. Murphy saying he signed my letter.
Right, but she doesn't provide any additional evidence to support the conclusion that he was actively a participant in the decision-making process, not in the communication process. I guess that's where I draw the distinction, right? There's the decision-making process, and then there's the communication process.
That's why I asked about reasonable inferences, which we are to draw in Ms. Murphy's favor.
And respectfully, I disagree that there's a factual inference there that would allow the court to find that there was potentially some pretext. There's nothing else in the record that would support that, and the district court disagreed with that analysis that was made by Ms. Murphy before the district court. I do want to touch briefly on the FMLA. I know that counsel didn't address that. The only issue that Ms. Murphy presents on appeal with respect to her FMLA claim is this doctrine of equitable tolling. And there are really only two Seventh Circuit decisions that have previously addressed equitable tolling. Both of us have cited those cases. The first is the Rodney case, I believe. And I want to point out that the law requires an employee to engage in some active process. There has to be some indication that she had a duty of diligence, that she diligently was trying to get that medical certification prepared and completed on time. That's, in my opinion, that's the distinction in the Townsend case. And here, the evidence is clear. Ms. Murphy was given the medical certification. She understood what the consequences were of not providing that medical certification within the 15-day time period. She testified that she knew that, yet she didn't provide, and as Judge St. Eve recognized, there's no evidence in the record that Ms. Murphy had any explanation for why she didn't give that certification form to her healthcare provider before the 3 days before the
Counsel,
deadline.
if she had put in a declaration at summary judgment saying, I was depressed, I was laid up in bed, I was having adverse reactions to my new meds, I couldn't get to this on time, in your view, would that be enough?
I think it would be. I think the FMLA provides that, again, there has to be some evidence of due diligence on the part of the employee. Unfortunately, this record doesn't have any of that evidence in the record. So without that, there's no evidence that what she did was diligent.
Is there any evidence as to whether MetLife would grant extensions on that form if requested?
I don't know the answer to that question. But all of the communications from MetLife did indicate that if she failed to provide that medical certification, that her leave could be either denied or delayed. Again, she was required to provide that certification by June 30th. By July 6th, she still had not provided that med cert, and then she received another communication from MetLife specifically telling her that because she had not provided the medical certification, that her request for leave had been denied. Again, to your point, Judge, I think she could have contacted, if she was in the process, she could have contacted MetLife and said, I'm in the process of trying to get this information to you, but she didn't provide that information to MetLife. She didn't provide it to Roundy's. She just simply, did nothing, unfortunately, and continued to take leave, which wasn't protected under the FMLA and wasn't protected under the ADA and wasn't protected under Roundy's policies, and that's the reason that her employment was terminated. I do want to address quickly just a comment made by counsel regarding a question about whether, if there was a request for FMLA, should Roundy's have asked about other forms of accommodation? And I think the answer to that question is no. Because if Roundy's tries to dissuade Ms. Murphy from taking FMLA, that can look like FMLA interference or FMLA retaliation. Most employers will provide FMLA to an employee when they request it. And there's limited information that an employer can require when an employee utters the words FMLA, which is what Ms. Murphy did here. So the appropriate response is what Roundy's did. It provided her with the contact information for MetLife and said, this is how you apply for FMLA. She had previously applied for FMLA. She knew what the process was. And
I take Mr. McDonald's point to be, it doesn't have to be that the employer dissuades the employee from seeking FMLA leave, but also opens the conversation up to other accommodations that might be warranted based on whatever the employee is talking about.
And I think that runs the risk for an employer of an interference claim by trying to discuss something other than leave. My understanding of the FMLA is once the employee needs has requested leave, you give them the paperwork and let them go through the process. If ultimately their leave is not necessary, then you can potentially discuss other forms of accommodation. Thank you for your time.
Thank you, Ms. Pfeiffer. Mr. McDonald, you have a bit of time for rebuttal.
Thank you again, Your Honors. I first wanted to address the last thing that was discussed, and that was the question of should an employer ask about other accommodations if an employee asks for FMLA. And it's certainly consistent. You can do both at the same time. Just because an employer starts talking about potential accommodations or other ways in which the employee could remain employed doesn't give any or present any chilling effect on the FMLA. All the employer has to do is provide the forms for FMLA. Then it's on the employee whether they want to apply for it or not, while still taking the humanistic approach and doing what they really should do and see, is there something that we can do to help you as the employee continue to perform your job? Secondly, I wanted to address the issue of pretext here. And as Your Honors pointed out, Mr. Stadgewitz did sign the letter. He denies signing the letter, which is odd. But Mr. Stadgewitz and Mr. Grant, they're incredible witnesses to begin with, so further lending support to pretext is the fact that, especially Mr. Stadgewitz, denies even having these conversations with Ms. Murphy regarding disabilities and accommodations. Now he's denying having any involvement in the termination process, I think, certainly supports an inference that he did in fact have some type of participation in that termination process. Thirdly, what I wanted to address is the position that Ms. Murphy did not contact Roundy's while her FMLA application was being processed and asked for an extension or to provide them with any more information. As pointed out in our brief and as indicated in the record, Roundy's directed Ms. Murphy to run all communications through MetLife.
Is there any evidence that she asked MetLife for an extension?
There's no evidence that she asked for an extension, but there is evidence that she received an extension, in that MetLife, after receiving additional documentation, then approved her application on August 2nd. So although there may not be an email or a telephone call that's specifically noted wherein Ms. Murphy asked for an extension, there was an extension that was granted. And as Roundy's admits, Roundy's did not contact MetLife and say, stop the process, she's fired, she's no longer with us. It let MetLife do their thing, so to speak. And what MetLife decided, based upon all of the information submitted by Ms. Murphy, was that she was entitled to leave under the FMLA, and it covered all those absences for which she was terminated, in particular the July 11th, 15th, and 16th, where Roundy's contends she was absent without approval. Another issue that we have with that reason for termination, that she was absent without approval, is, as admitted by Roundy's, she continued to call in every day as required by the employee handbook. Her supervisor, Sadowitz, was getting emails every day that she called in saying she's not going to be into work today. She's called in. They don't have to give a specific reason for that. It's just noted in the system, so they were aware of it. I'm out of time. Thank you very much.
Actually, I have a question on
Yes.
FMLA leave. May I?
Yeah, of course, please.
Did you seek discovery on the timing of FMLA terminations for not getting your leave approved? Because Roundy's did act with it was quite speedy. Did you seek any evidence of how this typically goes down in terms of timing? When someone has applied, they're not approved.
I understand your question,
Yeah.
and no, we didn't seek discovery on that particular issue.
Okay, thank you.
Thank you.
you.
Thanks to both counsel. The court will take the case under advisement. The next case for oral argument this morning is United States versus Beasley, appeal number 23-2489. Good morning.
Forgot my legal pad last night.
Good catch.
Thank you. All right. Good morning, Your Honors. May it please the court. My name is Colleen Rameh, and I'm here on behalf of defendant appellant Alvin Beasley. A lot has been made in the briefing on several subjects, but I would like to begin today addressing the government's harmless error argument. While we stand by our argument on structural error based on the charging documents in this case, I wanted to draw the court's attention to United States versus Maez. In Maez, which has been cited by both parties, the court did kind of a deep dive into the universe of considerations when we're on plain error review versus harmless error review. Maez says the Supreme Court has made it clear that harmless error analysis looks only to the trial record to measure the effect of a trial error. It went on to say, an effect on the verdict can, of course, be measured only against what the jury saw, hence the restricted record for the substantial rights analysis. It is only on plain error under the fourth prong that the court is allowed to consider information in a PSR or other information that may have been introduced at sentencing. So under either the structural error argument or harmless error argument, the answer here is clear. There is no evidence at trial of the timing of Mr. Beasley's prior offenses to meet the occasions prong of the inquiry under.
But has that limitation been placed in sentencing cases, in Apprendi type cases, or cases where the focus is on sentencing?
When we are under de novo review, yes. So here we're on de novo review. Mr. Beasley went to trial, preserved all of his rights, made the objection at the appropriate time. So, we look at cases like Cotton, and Cotton was plain error. When we get to the courts have talked about plain error and discussed a difference. Now, I understand that this ultimately goes to sentencing, but it is still an element of an aggravated offense. And so, yes, it is a sentencing factor, but it is not simply sentencing factor as it changes the elements of, the sentencing range.
If it's sentencing,
yes.
Why would the court's analysis be limited to just what was presented at trial?
Because that's the only thing that we have to go on when we are doing a harmless error analysis for a preserved claim for a trial. It was the government's burden, we now know, to properly charge Mr. Beasley with the offense it wanted to convict him of and sentence him to. and it did not do that, and it did not present the required evidence at sentencing. Now, some of the Elaine and Apprendi cases where we were talking about the quantity of drugs making a difference to, no one charged the jury with determining a quantity of drugs, but it made a difference for sentencing. Inevitably, that information was before the jury. So when the courts looked back at it to do a harmless error analysis, they looked at what was presented at trial. So there was information at trial presented to the jury that talked about, well, we weighed the drugs that were confiscated, and we did an analysis, and here's how much there was. And so
I'm not sure that's always the case.
When I went back and reviewed when it wasn't the case, we were on plain error. Justice Sotomayor, so when Maez was talking about the Rahafe element, the new element in Rahafe, and in Greer, Justice Sotomayor she concurred in Greer, and she really underscored the difference between plain error and harmless error in a trial case. And she said, she reminded courts that in a case like ours, where a defendant contemporaneously objects and is wrongfully overruled, appellate courts generally review for harmless error. In that case, when that happens, the defendants have not forfeited any of their rights, including their right to have a jury decide whether there is reasonable doubt as to any element of the crime charged. Now, the government's argument is that they they charged this offense. Our argument is that they didn't. But even if we assume that they did, appellate courts cannot find errors harmless simply because they believe that inculpatory evidence the government never put before the jury, like Greer's pre-sentence investigation report, is sufficient to find the defendant guilty. That's on page 517 to 518 of Greer.
Is that the concurrence?
That is the concurrence. And Greer was plain error. It was not objected to. And so in concurring, she was underscoring the difference between when we're on plain error and when we're on harmless error review. Respectfully, I don't think it matters that it's sentencing versus an inherent element of the offense. We are talking about an aggravated offense. This is an aggravated version of being a felon in possession that Mr. Beasley was sentenced for, and no information about this element was presented to the jury. So even under harmless error review, the court must reverse. I'd be happy to talk more about other things, but I realize I'm getting very close to my rebuttal time.
Right. Thank you.
Thank you.
Good morning.
Good morning, and may it please the court. Jeff Kinstra on behalf of the United States. It's undisputed in this case because the defendant conceded that the defendant committed an armed robbery in March 2004, that he committed an aggravated battery over a year later in June 2005, and that he then committed a murder over 6 years after that in December 2011. No rational fact finder could reasonably doubt whether those offenses were committed on different occasions.
Can I ask you about that? Because it picks up on where Ms. Ramey was. Where he conceded it in the case we have before us was at sentencing.
That's correct.
So if we are supposed to imagine what a reasonable jury would have done, let's assume we agree with you that we need to conduct harmless error. How do we imagine that based on the concession when the concession only happened at sentencing?
So the circuits have said a lot about this, actually, and they're unanimous in their viewpoint. And what they say is that the harmless error review looks to all relevant and reliable information in the entire record, and that's evaluated on a case-by-case basis for reliability without excluding any categories of evidence, and it's not limited to the trial record. The circuits have uniformly said that, including in cases in this precise posture where the defendants went to trial, the issue wasn't addressed at trial, but then the defendant then objected at sentencing.
Have we specifically said that? I'm sorry to interrupt. Have we specifically said that?
This court has applied that principle without explaining it. It applied that in Gamez. It also in Rodriguez, I think, and I think I have that case name right, in a non-precedential decision where it actually found an error to be harmless based on the entire record. And in fact, I take defense counsel's points about what Mays said, where in Mays the court was evaluating a Rahafe error. But in fact, Mays has been directly abrogated by the Supreme Court in Greer, which addressed that very same question and used the same language that the courts of appeals have been using in analyzing Erlanger errors, specifically that the record includes all relevant and reliable information in the entire record, evaluated on a case-by-case basis without excluding any categories of evidence. And so then, now, to be sure, Greer itself arose in the context of plain error review instead of harmless error. But that brings us back to Mays then, which recognized a long-standing principle, a well-settled principle in this court's case law, that the scope of the record is identical as between harmless error and plain error. Mays addressed that. This court earlier in Mansouri made that express point that the record is the same as between the two. And Greer definitively established that the record for the substantial rights inquiry, in fact, looks to all relevant and reliable information in the entire record. And so when you combine that with this court's settled precedent that the scope of the record is the same as between the two inquiries, that necessarily leads to the result that the same record applies here. That's the uniform view of the circuits that have addressed this. And that's also consistent with practice and principle. In cases like this, as Greer recognized, an alternative view would essentially posit an unrealistic scenario where this is actually presented to the jury is instructed, it has to decide this, but that the government doesn't actually attempt to discharge that burden. And that concern is even more pronounced here, because not only, like in Greer, did the defendant stipulate to his prior felony conviction, which prevented the government from addressing this at trial. And on top of that, he testified, he called another witness, and for both of those contexts, he expressly and affirmatively opposed any reference to the nature of his prior conviction. So it's the defendant's own doing that this didn't come up at trial. And then at sentencing, he admitted the facts, which essentially relieves the government of any further burden. That sort of stipulation is equally conclusive at trial as it was in this sentencing proceeding. And that point that Greer was making is even more pronounced here, because this isn't a situation like in Rahafe, where in the district court, nobody realized that, in fact, that knowledge element needed to be addressed. And so the defendant there had actually no incentive to develop the record, at least for the sake of that finding. Here, everybody knew all along that this finding had to be made. The defendant would only be sentenced under the Armed Career Criminal Act if, in fact, the court found that he had his 3 prior violent felonies that were committed on occasions different from one another. So the defendant then had every opportunity and every incentive in connection with this sentencing phase, where everyone knew it was going to be decided, to contest this issue. He had an opportunity to argue to the district court about if he didn't believe the information before it was reliable, or if he didn't believe that information satisfied the finding. Or he could have introduced additional evidence if he thought there were any that bore on this question. Instead, he took the exact opposite approach, and he openly conceded to the court that the felonies were, in fact, committed over a year apart. And these weren't sort of on-the-spot or off-the-cuff statements by defense counsel, as I think the reply brief tries to characterize them. This was the defendant's own sentencing memorandum.
Is it your position that you would want us to decide based only on the concession? Or are you asking us also to look at the district court's reliance on the PSR?
I think precedent shows that that's all fair game. The court looks at the entire record. So as the courts of appeals have recognized in applying this standard and looking at the record, that includes statements in the pre-sentence report that haven't been objected to, that includes other evidence in the record, and that includes, of course, the defendant's admissions, all of which are present here. The pre-sentence report reflects the dates of the offenses. The defendant not only did not object to them, he expressly explained in his sentencing memo that those were correct. And that's on page 8 of docket entry 66, where the defendant wrote that the armed robbery, quote, occurred.
I'm just wondering, what do we have here besides the PSR and the concession? Just those 2 things? You seem to have mentioned a third sandwiched in between there.
The judicial records of the
From the underlying convictions.
Correct.
That were introduced at trial.
No, in connection with the sentencing phase. The defendant stipulated at trial, so the records were not introduced at trial itself. So as courts have recognized, the harmless error review can be conducted based on the basis of the entire record, and courts look at the records on a case-by-case basis for reliability. Here, the defendant had every incentive to contest the information if he thought it was inaccurate, but he conceded that the armed robbery was in fact committed on March 21st, 2004, that the aggravated battery occurred over a year after that.
The reason I was asking is because I am wondering, after Erlinger, whether on harmless error review we can rely at all on the judge having looked at the PSR and Beasley not objecting to the PSR. Because as you know, Erlinger spills a lot of ink about no judge should look at, Shepard documents to make this PSR determination. And here we have the PSR is what the government is pointing to, among other things. And we have another case, Richardson, for example, saying, well, if a defendant doesn't object to the PSR and the PSR has this information, we're going to just assume the PSR relied on these Shepard documents. Do you see the tension I'm pointing to there? And so I'm wondering if you even need us to go down that road for your position.
So for our position, the defendant's concessions are sufficient. As to the Erlinger's point about Shepard documents, I don't read the language there as strongly as Your Honor characterized it. I think the court certainly pointed out potential deficiencies with Shepard documents. This is an argument that's been frequently made by defendants who are raising Erlinger claims, and the courts of appeals have uniformly recognized that, yes, as Erlinger explained, caution is appropriate when looking at Shepard documents, and so that's why courts have also looked at things like, did the defendant admit it? Is there other evidence on the record on that score? But I think this case really presents the clearest possible example, because it's not just a case where the pre-sentence report cited documents or where the judicial records are there. We have the defendant expressly agreeing, both in his sentencing memo and then again at the sentencing hearing itself, to the relevant dates.
It seems like some of those cases, too, in saying caution with the Shepard documents, we're discussing more the error in the first place as opposed to the harmlessness of it.
I think that's correct, because courts have uniformly been willing to at least look at the Shepard documents, consider on a case-by-case basis, as the Supreme Court precedent requires, whether those are suitably reliable to address the particular finding that the court needs to make. And this case, I think, given the defendant's agreement, makes that a clear case. Just briefly on the application of the standard, the defendant in his reply brief hypothesizes some potential factual connection between the offenses, and that's just immaterial, even if we were to assume hypothetically that were accurate, because that wouldn't change that the statute is specifically focused on where the offense is committed on occasions different from one another. So even if purely hypothetically there were some factual connection between these two different offenses, they were not committed on the same occasion when they were committed on two entirely different dates and different years.
Can I ask a clarifying question about how you started? Are you hoping that are you saying we don't even need to decide the structural error versus harmless error question because, I believe you're arguing now, the analysis is the same at the end of the day?
This court does need to decide structural versus harmless, because if it were structural, then we don't even go down this discussion that we've had during oral argument. And of course, I'm happy to answer Your Honor's questions on the structural versus harmless. Our view is that that's well settled in this court's precedent. Unless Your Honors have any further questions, we'd ask this court to affirm.
Thank you.
Thank you.
Thank you, Your Honors. I am looking at the page of the PSR that contains these two prior convictions. The PSR discusses the information on each of them. It wasn't even brought before a grand jury. We cannot, what the government's argument amounts to is no harm, no foul. There was an error at trial. We can clean it all up at sentencing and sentence you to a sentence that would not be permissible based on what we charged you with, all based on information that they could not present at trial. It sort of boggles the mind, because if this had been done the way Erlinger tells us it should have been done, we would be looking at a situation where the government would have to bring in competent evidence that Mr. Beasley could have objected to prove the occasions on which these happened. So whether or not they did happen on, March 21st of 2004 and June 11th of 2005, the government would still have to bring in evidence that would be tested by the adversarial process and have to prove that at trial. Mr. Beasley never gave up this right to have all elements of the offense charged against him proven to a jury.
If we can look beyond what was presented before the jury, do you agree that his concession in the sentencing memo is sufficient for harmless error?
No, Your Honor.
How do you get around the fact that he agreed in his sentencing memo that these offenses were committed more than a year apart?
Because he still stood on his rights, to have the government prove that with admissible evidence, and he also, as I presented in the reply brief, there would be an argument he could have made to the jury. I think it is entirely plausible, based on when these things were charged and how the sentencings happened, that they were connected. And now I understand that 15 months or so is a long time between events, but because we are no longer looking at a specific amount of time, he could have made an argument to a jury. We do not know what kind of evidence would have come out.
Do we take into account the state of Illinois law and the fact that there is Illinois law that related offenses should be charged together, or that sentences are run concurrently if they're imposed at the same time, even if they're not related cases? Do we take all that into account when evaluating the argument that you're making about what he could have presented to a jury?
Your Honor, you might. I would go back to my previous arguments, but the sentences did run concurrently. They were charged in different indictments, but they were run concurrently. And, ultimately, I don't know that a jury, this is a fact question. The occasions issue is a fact question. So a jury would have to make the finding. We wouldn't know what a jury might hang on to. And honestly, what evidence would be presented at all of when he made these? Because they can't come in with an information that to prove it's hearsay upon hearsay, right? We're dealing with all sorts of evidentiary problems with just walking into court with the information charging these things. So we would have to even get to the point of making arguments in front of a jury. This cannot be harmless, where it radically changed the sentencing that Mr. Beasley was subject to.
Thank you.
Did that answer your question, Your Honor?
Yep, I did.
I'm sorry.
Thanks to both counsel. Court will take the case under advisement. Our last case for oral argument this morning is Simmons versus Garrett, appeal number 24-3194. Good morning, Mr. Suska.
Good morning, Your Honors. Thank you, and may it please the court, David Suska for the petitioner appellant Tiffany Simmons. This court should reverse the order dismissing Ms. Simmons' habeas application. The district court ruled that Ms. Simmons' Miranda claim was not cognizable in habeas because she pleaded guilty. That ruling is impossible to square with the Supreme Court's holdings in Withrow and Lefkowitz. Withrow held that Miranda claims are cognizable in habeas, a holding affirmed in Cohane and then Dickerson. And Lefkowitz held that a guilty plea does not cut off habeas review of a constitutional claim, at least not whereas here, state law allows the guilty plea while preserving the claim for direct review. Putting Withrow and Lefkowitz together, this court must reverse. Indeed, the four circuits that have addressed this issue all agree that a Miranda claim is cognizable in habeas in precisely this context.
They haven't addressed it since Vega, though, correctly?
That's correct, Your Honor. And that's respondent's principal contention, is that Vega changed everything, to use the quote from respondent's brief. And I don't think that's right. In fact, I think Vega didn't change anything. By its terms, Vega declined to extend the Miranda right so that damages liability might be available under 1983. But declining to extend the right is not the same thing as cutting back on it. And Vega didn't purport to overrule Withrow or Lefkowitz. This court can't overrule those decisions, of course.
In fact, they approvingly cited Withrow
I think that's right, Your Honor.
in Vega.
That's correct. That was an essential premise of the reasoning in Vega was that individuals can already vindicate their Miranda rights in other contexts, including in federal habeas, based on Withrow. And as we point out in our reply brief, this court has continued to adjudicate Miranda claims on the merits in habeas, where the defendant pleaded guilty and state law preserved the Miranda claim on direct review. Those are all post-Vega cases. It's impossible to square those dispositions with the position that respondent takes here. Now, perhaps because the law is so clearly against respondent on the question certified for appeal, respondent devotes portions of his brief to questions that were not. The merits of the Miranda claim, for one, and whether the district court should have granted a certificate of appealability for another. As we've explained in our reply brief, there's of course no basis for reaching the merits of the Miranda claim here. That's for remand. And there's nothing to the suggestion that the certificate was improperly issued. Certainly not in light of this court's earlier order dismissing respondent's motion to dismiss.
How do you reconcile the Supreme Court's opinion in Lefkowitz, which says in order to proceed where the state says you can raise a constitutional claim post-guilty plea, and Vega, which says a Miranda claim is not a constitutional claim?
I would swear.
You might be right that, and we can't reverse the Supreme Court. But how do you reconcile those two?
Sure, I reconcile them by going back to Withrow. And so if you look at a paragraph that starts on page 690 of Withrow, the court actually addresses almost this precise question. It almost anticipates the question, and it says, something like, petitioner argues that Miranda is just prophylactic, not constitutional, and therefore habeas relief cannot lie for a Miranda claim because the habeas statute refers to a constitutional claim. And the court says, we're willing to accept the premise, which is that Miranda is prophylactic, but not the conclusion, which is that a violation of that prophylactic rule is not a violation of the Constitution, at least for purposes of the habeas statute. And so that's how you sort of square Withrow with Vega, as you understand, as a matter of the Supreme Court's precedent, what is constitutional for purposes of the federal habeas statute is not necessarily constitutional for purposes of 1983. That's the law as this court has to take it. That's the law as Ms. Simmons takes it.
Have they held that in any other context, that something is constitutional outside of, or not constitutional outside of habeas, but constitutional for habeas? That
I can't point to another context, and I can't defend all of the court's Miranda jurisprudence as sort of entirely coherent, but I think in this domain it is entirely coherent. Withrow does not cut back at all. Vega does not cut back at all on Withrow. As Your Honor noted, Vega actually relies on Withrow as a reason for not extending the Miranda right in the 1983 context.
that could be true for Withrow. I think Lefkowitz is a separate question than Withrow. That Withrow doesn't answer the post-guilty plea question.
I think that's right. Lefkowitz, the holding in Lefkowitz is an essential premise of our argument to the court. That's right. Yes. If there are no further questions, I'm prepared to come back at rebuttal.
Okay, thank you.
Thank you.
Good morning, Mr. Held.
Good morning, Your Honor, and may it please the court. Simmons has conceded virtually every argument in our response by not addressing them in reply. She's conceded that there's no habeas jurisdiction over her claim, that there should have been no certificate of appealability even if there were, and that she could not surmount 2254 D1 on remand given things that we already know. Simmons relies purely on Withrow and Lefkowitz. She attempts to apply those cases' particular concrete results non-contextually. Mr. Withrow could bring his Miranda claim in habeas, so she can too. Mr. Lefkowitz could bring his First and Fourth Amendment claims despite his guilty plea, so she can bring her Miranda claim despite hers. But those are non sequiturs. Simmons ignores that the Withrow court didn't address jurisdiction and told us that it wasn't doing so, and that intervening Supreme Court precedent indicates there is no jurisdiction. She ignores that an intervening act of Congress and intervening Supreme Court precedent indicate that there's no basis for a certificate of appealability, and she ignores that under 2254 D1 she can't prevail regardless of the merits of her claim because Supreme Court precedent doesn't make clear that a defendant whose statements are not used against her at trial can invoke Miranda. And she ignores that the First and Fourth Amendment violations in Mr. Lefkowitz's case were alleged to have actually occurred, unlike the Miranda violation in her case. This court should either affirm or vacate the certificate of appealability, and I welcome the court's questions.
You've asked us to make a broader holding, I think, than is required here, that you could no longer bring a Miranda claim in habeas post Vega. I don't know how you could get there given Vega's reliance on Winthrop and affirmative reinforcement of Winthrop.
I have an answer for that, Your Honor. Simmons argues that the Vega court implied that habeas jurisdiction would continue to apply over Miranda claims, but we disagree. Simmons presents her core argument thus, cherry-picking 3 pieces of Vega in the following chimeric quotation, quote, from their brief, and there are internal quotes. So, quote, after examining post-Miranda decisions, the court, internal quote, refused to extend Miranda, end internal quote, to 1983, reasoning in part that individuals can already vindicate their Miranda right, internal quote, in other recognized contexts, end internal quote, and the following is emphasized by them, including in federal habeas based on Winthrop.
I actually agree with you that the end of Vega does not say including federal habeas. It just says in other recognized contexts.
Right.
No, you're right.
But there's more. I'll let Your Honor ask the question.
Why don't you go?
I've got more about the context, Your Honor. So a more complete quote from page 151 of Vega, which is the 3 pages they crammed together here, is that Miranda's, quote, prophylactic purpose is served by the suppression at trial of statements obtained in violation of Miranda and by the application of that decision in other recognized contexts. And Simmons quotes only the last 4 words of that and argues that it implies that the court was assuming that habeas jurisdiction would remain for Miranda claims. But that doesn't follow, and here's why. 1, it seems odd that the Supreme Court would assume that habeas relief would remain to vindicate a rule that it had just announced on the previous page is not required by the Constitution. And number 2, why would the availability of habeas corpus relief matter in a case where the plaintiff wasn't convicted as an alternative to 1983, which is typical of 1983 claims based on Miranda when you could bring them? So what does other recognized context mean if not habeas? It means things like preliminary hearings and suppression hearings. Those are the kinds of, quote, contexts that are distinguishable from the context of, quote, suppression at trial. Habeas relief is not a, quote, other context with respect to suppression at trial. Like a direct appeal, habeas is a form of review as to whether suppression should have occurred at trial or any other stage.
Then how do you explain the court's acknowledgement and positive citing of Winthrop, where it's discussing post-Miranda cases where they've engaged in the cost-benefit analysis?
Right.
And citing that approvingly, that differentiates these cases.
Because the court did 2 things with respect to, it had to make 2 rulings when it decided whether it was going to continue to recognize Miranda claims in 1983. First, it had to decide, does the Constitution require Miranda? And it said, no, it doesn't. So then it says, well, is it a law of the United States? And they said, well, it doesn't matter if it is. We're not going to go there, because even if it is a law of the United States under Section 1983, we still then do a balancing to determine whether we're going to continue to view it. And they looked at the balancing that was done in Withrow as an analogous type of balancing. But that doesn't mean that they were saying that this can continue to arise.
But they don't say, and we were wrong there. They're relying on it.
Well, they're using it as an analogy, but they're certainly not deciding that there's habeas corpus jurisdiction. It's not a habeas corpus case. They said in Withrow itself that they weren't addressing habeas corpus. In fact, quote, from Withrow, today we hold that Stone's restriction on the exercise of federal habeas corpus jurisdiction does not extend to a state prisoner's claim that his conviction rests on statements obtained in violation of the safeguards mandated by Miranda. Later, it noted that the Stone rule is a prudential application of 2243, not a jurisdictional interpretation of 2254A. Quote again from Withrow, we have made it clear that Stone's limitation on federal habeas relief was not jurisdictional in nature, but rested on prudential concerns. And then it goes on to discuss the difference between 2243 and 2254. The dissent agreed. Justice Scalia, quote, "The issue in this case, whether the extraordinary remedy of federal habeas corpus should routinely be available for claimed violations of Miranda rights, involves not jurisdiction to issue the writ, but the equity of doing so." And I believe the words jurisdiction and equity are emphasized, and that was a point of agreement between everybody on the court.
What about the Supreme Court's opinion in Thompson versus Keohane, where they specifically said claims that state courts have incorrectly decided Miranda issues, as Withrow versus Williams confirms, are appropriately considered in federal habeas review?
Right, because they weren't, nobody was raising the jurisdictional question at that time, and I think that's a 2003 case maybe. I don't remember off the top
It's
of my head.
before then. It's
Before then.
late 90s.
Okay, well, certainly in the year 2000 in Dickerson, they declared expressly that Miranda is a constitutional requirement. In fact, that they had to, because that's how they overruled 18 U.S.C. 3501A, where Congress had purported to overrule Miranda. They said, no, you can't. It's a constitutional requirement. But that changed in Vega. Now it's not a constitutional.
Do you want to have any comment on the fact that the Supreme Court just denied cert in a Ninth Circuit case where the respondent raises the same argument you are raising here, that there's no longer habeas review for Miranda claims? That's Samuel
versus Carlin.
Carlin. Any comment there?
Well, yes. On the fact that the Supreme Court denied cert, yeah, the Supreme Court has said clearly that when they deny cert, nobody is supposed to take any kind of substantive, as if they're deciding any substantive answers there.
Mm-hmm.
The Samuel versus Carlin case, of course, was not published. I've got about 2 minutes left. And the Samuel court, we noted it was not a very thorough analysis. Our friends on the other side disagree, but it was a couple of paragraphs, and they essentially made the same argument that our friends on the other side made with the other recognized context quote. But again, why would the availability of habeas relief as an alternative remedy factor into the Vega court's concerns in a case where the plaintiff wasn't convicted, which is typical of 1983 claims? Nobody needs habeas relief under those circumstances. If you're bringing a 1983 claim for Miranda when that was allowed, then Heck v. Humphrey 1994 is there. So if you're bringing the claim, that means that you still potentially, you don't need habeas corpus relief, because if you're bringing the claim while you're still in prison or you haven't obtained relief already and gotten out, you're stopped by Heck v. Humphrey. You can only bring a Miranda claim under 1983 if habeas has nothing to do with it anymore. So it doesn't make sense that the Supreme Court would think, well, you're good enough with habeas as an alternative, because that wasn't a thing if you're bringing a 1983 claim. And it's also, again, it's strange to think that they'd be reasoning that habeas jurisdiction would continue to lie for violations of a rule that was expressly holding not to be required by the Constitution. And the Samuel court, of course, concluded with an unobjectionable statement that lower courts should not anticipatorily overrule higher precedent, which of course they shouldn't, but that's not what we're asking for. We're asking the court to apply its precedent, but we're asking the court to apply all of its precedent and all of the statutes, not just one case, Withrow, as a non-contextual absolute. You need several things to get habeas corpus relief, and Mr. Withrow had all of them. He had the continuing operation of the writ. Congress hadn't suspended it. He had a jurisdictional statute that wasn't challenged. He had the underlying Miranda right, and he had the 2243 determination that Stone v. Powell wasn't going to apply. He had all of those things, but if you take any of those away, you can't get habeas anymore. And the thing that's been taken away here is the jurisdiction. I only have 17 seconds left. I'd like to get in one thing real quick. Revisiting the certificate of appealability is permissible at this court's discretion under its case law. We asked the court to do it in this case because in this court case it will save time. If the court decides that you can't get a certificate because Miranda is not constitutional, this court will never again have to address a Miranda claim under Section 2254 where the petitioner loses in the district court, which is most cases. It will save time going forward, as opposed to in most cases you're just arguing over whether the facts are close enough, and if you've already got the briefs, it's a waste of time to argue that. That's not the case here. It's an either-or legal question.
Thank you, Mr. Held.
Thank you, Your Honor.
Mr. Suska?
Thank you, Your Honor. Withrow and Lefkowitz make this a simple case. My friend on the other side is essentially asking for this court to sort of anticipatorily overrule those decisions based on some tea leaves in Vega. Of course, this court cannot do that. To try to avoid the sort of understood bar on this court anticipating and overruling the Supreme Court precedent. My friend on the other side tries to characterize his arguments as jurisdictional. It makes no difference whether you characterize the arguments as jurisdictional or not. This is a simple case under Withrow and Lefkowitz, and we ask that the court reverse the order below.
Thank you, Mr. Suska.
Thank
And
you.
you and your firm were appointed to represent your client
Yes.
in this case. Thank you for taking the case on and for your fine advocacy on behalf of your client.
Thank you.
The court will take the case under advisement. Thanks to both sides, and that concludes our oral arguments for this morning.